Welcome. Let's work our way through a federal civil procedure hypothetical from a past bar exam. And as always, please help us grow this channel by subscribing and by liking the video, assuming it helps you and you find it useful. If you came across this on a bar exam, the first thing you would see is 3 calls. And you would immediately figure out that it's federal civil procedure, and that would narrow down what you would need to have in your active memory, in your mind, as you read the facts. Because what you're trying to do is immediately spot issues and spot the legally relevant facts that you would use to analyze those issues. So in this one, I see 3 calls. First I see, was the trial court correct in denying the motion of Don's Market to dismiss the complaint on the ground that the court lacked subject matter jurisdiction? So the first call is straight SMJ. But this is framed like a double negative to me, so I've got to turn it around in my mind. It says the court was correct in denying the motion that the court lacked subject matter jurisdiction. In other words, I'm being asked, was the court correct that it had subject matter jurisdiction? The second call, was the trial court correct in denying Rita's motion for change of venue? Well, a motion for change of venue means we're talking about Section 1404, transfer of venue. That means that I have to do an SMJ analysis on wherever she wants to change venue to, and then look at the factors. Fairly complex call. Call 3, was the appellate court correct in dismissing Rita's appeal? I'm not sure exactly what that call is, so we'll go into it further when we get the facts and know what it is. It may be that this is an interlocutory appeal. Bar exams like to test that rule about interlocutory appeals. We'll see as we go through this. But first, I know that subject matter jurisdiction is a huge part of this answer. It's call 1 in total, and it's involved in call 2 because you can only transfer venue to a place where there would have been jurisdiction in the first place. So let's take a look at the organized structure I would have in my mind for subject matter jurisdiction that would help me in reading the facts and lining up legally relevant facts. So we're talking about subject matter jurisdiction, the power of the court to hear the kind of complaint being brought. What do I know about subject matter jurisdiction? Well, I know that the court has original jurisdiction in a couple of ways. It has exclusive jurisdiction over some cases, but it has concurrent jurisdiction. In other words, jurisdiction along with the state courts in a lot of cases. Those cases are limited to federal question or diversity cases. And I assume we're talking about diversity here. The amount in controversy must be a good faith allegation of more than $75,000. We can aggregate claims. I suspect we have a single plaintiff against multiple defendants here. And so the plaintiff may not aggregate each claim against each defendant unless the defendants are jointly and severally liable. She may aggregate any claims against a single defendant. Sometimes they give us straightforward amount in controversy that meets that. Other times there are dense facts and we need to worry about all of this. But the other thing we need for diversity jurisdiction is that we have to think about complete diversity of citizenship. So amount in controversy and complete diversity. What do we need for complete diversity? We need to have no plaintiff domiciled in the same state as any defendant at the time the action commences. For an individual, there's one domicile, the true fixed place of residence where they intend to remain or to return after an absence. For corporations, there are two domiciles, place of incorporation and principal place of business. Okay, so assume we have an individual here. How do we decide where the domicile is? This is frequently tested. Well, we look at things like current residence, where the person is registered to vote, location of property and assets, and things like where the car is registered. Any facts they give us that let us decide whether this person intends to remain or likely is there temporarily. That, I think, is the crux of what I need to know about subject matter jurisdiction. Let's see what we have in the facts. It starts right off with Pam took an indefinite leave of absence from her job. That sounds like this is not permanent. She intends to return to wherever her job is. Sublet her apartment in State A. Okay, so she's in State A working. She takes a leave of absence and she sublets her apartment. Those are facts that let me argue that she intends to return to State A. She intends to remain in State A. And went to care for her elderly mother in State B. Well, we often wind up caregiving for our parents as they age, and we don't move permanently. So this looks like this fact pattern is setting up her intent to return to State A, that this is her home. Approximately 6 months later, while Pam was walking to her car in the parking lot of Don's Market in State B, Rita, a resident of State C, struck Pam with her car. Right, we've got 3 states involved. Call 1, the issue is going to be where is Pam domiciled, because we need to have her domiciled in a different state than any defendant in order for the court to have diversity jurisdiction. So she's been in State B for 6 months, which is a long amount of time, but they gave us more facts to indicate that she intends to return to State A. We know from the calls that Don's Market is a defendant and Rita is a defendant. Rita is State C, Don's Market is State B. So if Pam is domiciled in State A and we meet the amount in controversy, the court has diversity jurisdiction. That's what I would find, because I don't want to write myself out of the answer right in call 1 by finding that there's no subject matter jurisdiction. If there's no subject matter jurisdiction, that's the end of the story, and that can't be the case. So they gave me more facts to argue that Pam is domiciled in A, Rita is C, Don's Market is B. So we have complete diversity of citizenship. In Rita's car were 3 friends from State C who are traveling through State B with Rita. The friends told the police officer called to the scene of the accident that Pam was reading a magazine as she walked across the parking lot and was therefore not watching where she was going. Pam told the police officer that she had just walked out from behind a large concrete column in the parking lot when Rita's car struck her. What am I going to do with those facts? Well, the facts about the friends, that goes to witnesses and where the witnesses are located. That's one of the factors in analyzing a request to transfer venue. We'll come back to that. That's call C. But right now, I still don't have any facts that go to amount in controversy. And I don't know what this stuff about the column in the parking lot goes to. So let's read on. Pam sued Rita and Don's Market in federal court in State B. Pam's complaint sought $60,000 in damages against each defendant. It also asked the court for an injunction ordering Dan's Market to tear down the concrete column in the parking lot. So now we have the facts we need to look at whether the amount in controversy is satisfied. And if you'll recall from the law I showed you earlier on, Pam can aggregate all the claims against one defendant, but she can aggregate against the claims against the two defendants only if they're jointly and severally liable. I see no relationship between Rita and Don's Market that would mean that either was an agent of the other. So I see no joint and several liability. I see two defendants. I see Pam v. Rita and Pam v. Don's Market in the same lawsuit. One plaintiff, two defendants. Can we aggregate? If we can't, then there is no subject matter jurisdiction against Rita, right? Because it's $60,000 against each defendant, and that's not enough to meet the amount in controversy. As to Don's Market, there's also a request for an injunction. The value of the injunction will be added to that damages amount in order to look at the amount in controversy. What is that injunction worth to Pam? Or what is the cost of replacing that column? The court will value the injunction and will add it to the $60,000 good faith damages claim and likely find that there is sufficient amount in controversy to have diversity jurisdiction, at least against Don's Market. Against Rita, well, the court would have to somehow find that they were joint tortfeasors so that her claim could be aggregated with the one against Don's in order to meet the amount in controversy. Don's Market moved to dismiss Pam's complaint on the ground that the court lacked subject matter jurisdiction. The court denied the motion. Don's Market has a principal place of business in B. Pam is domiciled in A. Rita is domiciled in C. The court has complete diversity and the amount in controversy against Don's Market. They aggregate $60,000 with the value of the injunction, and they find complete diversity. So they were correct in denying the motion to dismiss for lack of subject matter jurisdiction. That's call one. Rita then moved for a change of venue of the action to federal court in State C on the grounds that she's a citizen of State C and that it would be a hardship for her and her witnesses to travel to State B for trial. The court denied Rita's motion for change of venue. Okay, let's take a look at the law here. So we know that venue has to do with the particular federal district court where the claim is filed. We know that venue is proper in a district where any defendant is domiciled, if all the defendants are domiciled in the same state. It's also proper where a substantial part of the claim occurred or a substantial part of the property on which the claim is based is located. So it looks like State B was proper for venue because that's where a substantial part of the claim occurred. The whole claim occurred there. But what about State C? Well, for that we have to worry about domicile. An individual's domicile is the same for venue as it is for diversity. But an entity, that means any district where it would be subject to personal jurisdiction if the district were considered a state. In other words, For venue to be proper in C, we would have to find that Don's Market was domiciled in C, and I don't see that. I don't see that Don's Market is subject to personal jurisdiction in C, so I would want that to be part of my analysis. But I also need to look at what's needed to have a Section 1404 transfer of venue. A court may transfer any case to any other district where the case could have been brought. So that district must have original jurisdiction. And then, even if we found the correct domicile for Don's, which I don't think we would because they're not subject to personal jurisdiction, the court would look at factors like the relative location of the parties, the location of the witnesses, the location of the evidence, relative costs, all of those factors. All of that is what I need to analyze to look at transfer of venue. Why am I not looking at forum nonconvenience? Because that's not a transfer. That's either a dismissal or a stay. This defendant is asking for a transfer. That's a Section 1404 transfer. So I'm going to analyze all that law, and bottom line, I'm going to find that State V is proper venue, that the court was correct to deny the motion to transfer venue. Rita then filed a notice of appeal of the court's denial of her venue motion. The appellate court dismissed Rita's appeal. That's call 3. And this is about an interlocutory appeal. Okay, what we're talking about here is the final judgment rule. We're talking about the fact that appeals are allowed only from final judgments, and they have to be within 30 days of the final judgment or the challenge to an order. Interlocutory orders are generally not appealable unless the issue is injunction. For Rita, the issue is not injunction. For Don's Market, it might have been, but not for Rita. What are the exceptions to that rule? Multiple claims where one is specifically enforceable. We don't have that here. Collateral order doctrine, class action certification, statutory discretionary exceptions. Well, I don't think we have any of those here either. Collateral order is something that's an important question, collateral or unrelated to the underlying merits of the dispute. So a common example is a ruling on whether someone is liable for indemnification. So call 3 looks like the shortest call I have to analyze. It's simply about the final judgment rule, and that's going to be pretty quick for me to do. If you've listened to any of my other debriefs, you've probably heard me say that I'm a slow writer. I'm really good at issue spotting hypotheticals and organizing my answer, spotting the issues. I have difficulty getting the answer completely written out in the time that I have. So I have to carefully plan my timing and hold myself to it. So I never assume that the 3 calls are equal weight, and I never start call 1 without planning how much time I have to do it, because I could easily spend the whole amount of time I have on call 1 thoroughly analyzing subject matter jurisdiction, and I can't afford to do that. On this one, call 3 is the shortest for me. Call 2, probably next shortest. Call 1 is going to take me the most time. This is a 1-hour essay. Takes me 15 minutes to issue spot the hypothetical and make sure that I've seen everything I need to see and that I still accurately remember the calls. So then I have to divide my 45 minutes of writing time to figure out how much to spend on each call. So I'm going to spend no more than 10 minutes on call 3. That leaves me 35 minutes for calls 1 and 2. It's not that call 2 is short, it's just that I will be able to refer back a bit to the rules I've used in call 1 because call 2 includes a subject matter jurisdiction analysis as well. So I'm going to give call 1 a bit more time. that 35 minutes, I'm going to take 20 minutes for call 1 and 15 minutes for call 2. If I can finish call 1 in less than 20 minutes, great. I'll give that added time to call 2. But that way, I'll finish all 3 calls. The only way I can do that is by having that organized structure of the law in my mind when I go into the exam. And you certainly will do that before you walk into a bar exam. I hope this has been helpful. As I said at the start, please subscribe to the channel. Please help us make this grow, and also, in doing so, provide feedback to me that it's worthwhile for me to do more of these.